just lost your job, or maybe your hours got cut, or your pay changed, or you got a raise. Whatever the situation, if you're paying or receiving spousal maintenance in Wisconsin, any major shift in income could mean it's time to modify. But here's the catch. The court doesn't care what you say. They care what you can prove. I'm Jeff Hughes, lead attorney and CEO at Sterling Lawyers, and we have helped thousands of Wisconsinites in family court. And in this video, I'll walk you through exactly how to document your income changes step by step so that your request doesn't get denied or delayed. First, the court only adjusts maintenance if there's been a substantial change in circumstances. Not every change counts. If you took a few unpaid days off, not enough. You got a $1 an hour raise, probably not either. Wisconsin courts only modify maintenance if there's been a substantial change in circumstances. And this usually means that there's been a job loss or a layoff, there's been a pay cut or a reduction in hours, a promotion, or a raise, serious medical issues that reduce your ability to work, retirement, or the other party remarrying or cohabitating. But again, it's not enough just to say it happened. You need proof. So how do you prove this? What documents do you need? Well, start by gathering the last 12 weeks of pay stubs before and after the change occurred. Termination letters if you were laid off, a new job offer or salary letters, or most recent tax returns, especially if you are self-employed. Unemployment benefit letters or denial letters. Recent bank statements showing reduced income or deposits. I think back to a client we had that was paying $1,200 a month in maintenance, then got laid off from his manufacturing job. He waited 4 months to file because he thought, well, the court would simply understand. By then, he was behind, and the judge refused to reduce support retroactively because he did not file sooner and had no documents to prove when the support income actually stopped. That single delay cost this poor man over $4,000. But what if you're self-employed? That's tricky. So here's what you need. If you are self-employed, the court assumes that you control how much money that you show on paper. So you will need 2 years of business tax returns, profit and loss statements, your Schedule C from your 1040, bank statements, invoices, and contracts. If you have reduced your work, you'll need to show why with documentation. Otherwise, the court may think you're just hiding income. We once had a client who owned a small plumbing business, and he said that business was slow, but he could not produce updated financials. Well, the judge imputed income based on last year's earnings and refused the modification. Well, after we were able to work with him and pull together his profit and loss statements, his customer cancellations in the recent months, the judge finally agreed to lower his support obligation, but it required an extra 3 months of payments and a second hearing. And if you're self-employed, don't forget your expenses because they certainly affect your ability to pay. So even if your income drops, the court will also look at these expenses because they relate to your ability to pay. So it's not just about what you make, it's about what you spend. So make sure you include mortgage, rent payments, utilities, medical expenses, car payments, child-related expenses, health insurance premiums that have gone up, and debt repayments that have changed since your divorce. The court is going to be looking for a full picture of your financial reality, not just your income side of things. And also, timing is everything. If your income changes, file the modification as soon as possible. Wisconsin judges generally won't go back further than the date you filed, even if your job loss happened prior to that. Waiting, that can cost you thousands of dollars in back payments. We once had a client who was a nurse, and she went from full-time to PRN hours and didn't realize that she could modify. And unfortunately, by the time she came to us, she was 5 months behind in her payments. And the court reduced her future payments, but she still had to pay those past due amounts. So documentation plus timing equals everything. And finally, if you are the one that is receiving support, you too can modify. If you're the recipient and your ex got a raise or suddenly stops paying, you can file to modify upward or to enforce the current order that's in existence. And what you'll want is proof of their raise or their new job. So look at LinkedIn, job ads, etc. Your own pay stubs and tax returns, records showing financial strain, past due payment records if they have fallen behind. Now look, judges take enforcement and upward modifications seriously, but again, only when documentation is solid. So if your income has changed, don't guess, Don't delay, and definitely do not show up to court empty-handed. But income documentation is just one part of the equation. In our next video, we'll show you exactly how the Wisconsin alimony calculator works, including the hidden factors judges use to increase, reduce, or deny maintenance entirely. Let's walk it through.